The broadcast is now starting. All attendees are in listen-only mode.
Good morning, everyone, or afternoon for our East Coast listeners. Thank you for joining us today. My name is Deb Erdman, and I am a Vice President and Trust Officer with Peak Trust Company. If that doesn't sound familiar, we are formerly Alaska Trust Company. We are very pleased to sponsor today's presentation, Curtailing Fiduciary Litigation. Before we introduce our speakers, I just have a few housekeeping items to cover. Today's webinar is going to be recorded and a replay will be emailed to everyone that has registered. So you'll get email following the presentation. Secondly, please feel free to post any of your questions in the box at the right-hand side of your screen in questions. Everybody is going to be muted during the session, and a Q&A will be held after the presentation is done. Now it is my honor to introduce the presenters. We have with us today Lane Rushforth, who is a principal at the law firm of Rushforth, Lee & Kiefer, LLP. He focuses his practice on matters involving estate planning, business planning, trust administration, and probate. Mr. Rushforth is licensed to practice in Utah and Nevada. He has been a fellow with the American College of Trust and Estate Counsel since 1990. He has been active in the estate planning community as a lecturer, an author, and an officer of an association of estate planners. His trust and probate practice includes representation before the probate court related to will contests and other disputes related to estates and trusts. And he has served as an expert witness in trust and estate cases involving fiduciary duties and attorney malpractice. And he's also a member of the Legislative Committee of the Probate and Trust Section of the State Bar of Nevada. We're also pleased to have with us today Jonathan Blattmacher. He is Director of Estate Planning for Peak Trust Company, again, formerly Alaska Trust Company, and a Director of Pioneer Wealth Partners, LLC, a boutique wealth advisory firm in Manhattan. He's a retired member of Milbank, Tweed, Hadley, and McCloy, and of the California and New York bars. He's author and co-author of 8 books and over 500 articles, and has been chair of several committees of the New York and American Bar Associations and the American College of Trust and Estate Counsel. He's also co-developer of Wealth Transfer Planning, a computerized system for lawyers that automatically generates estate planning documents such as wills and trusts, and provides specific client advice using a form of artificial intelligence. Jonathan has also served 2 years of active duty in the U.S. Army, rising to the rank of captain, and was awarded the Army Commendation Medal. He is an instrument-rated land and seaplane pilot and a licensed hunting and fishing guide in the town of Southampton, New York. So it sounds like, Jonathan, you can take us for a plane ride and teach us to hunt and fish while you set up our estate plan. That's wonderful. So with that, I'll turn it over to you, Jonathan.
Well, Deb, thank you very much for those kind introductions, and I hope everyone will want to really take note about what Lane and I are going to talk about, which is not something that people really talk about in the planning process, but it really deserves it. I mean, obviously, if you knew that a client was going to face a lawsuit in the future, for example, you were helping a client form a business, I think you'd feel compelled to tell the client that, gee, if you do this as a general partnership, you and the other partners are going to face potential liability if a claim against the company arises. And you'd probably recommend either a limited liability company or a limited partnership or a corporation to avoid that. Well, when you think about it in the context of estate planning, I think it's also true for matters relating to what I'll generally call fiduciary litigation. I think that you need to really think about warning your clients when you anticipate, either because of the way the will is structured or because of some other factor, that there may be a claim that arises after the client's death, or if it's going to be a lifetime transfer by reason of that lifetime transfer. So we're going to explore that, but again, I urge you to think about that and to counsel your clients about that possibility, even if the risk seems low. One thing I am certain of, no one who did her estate plan thought, gee, I want my money expended after my death on postmortem litigation about my property or about the administration of my property when I die and have most of the assets go to the lawyers. And I've had two estates where it happened. In one circumstance, the man died, left most of his estate to his two hopelessly retarded children. Disputes of all kinds arose during his lifetime, and the lawyers took 90% of the estate. There were over 22 law firms involved, took 90% of the estate, and his retarded children had virtually nothing after all that. The reason that this occurred is the guy died when he was only 46 years old, and of course he knew he didn't really have to make plans because he had decades more to live. So again, I urge everyone to take that into account. Lane, let's move to our first slide, and if you'd provide some introduction to our topic today.
Happy to do that. Thank you, Jonathan, or should I say Captain Blotmacher. It's a pleasure to be with all of you today, and what we're going to start with is just the types of disputes. And I look at the role of the estate planning attorney as the primary role that we're involved in is that of an educator. And in the past, we focused on wealth. We focused on who was going to get what and how they were going to get it. We were going to do tax planning. But one of the parts of the education that we're hoping that you get today is the fact that we also need to educate the client as to the potential for disputes that can arise. There are a number of things that can happen where they're going to do. The first one on the slide is the validity of the will or trust and how it's going to be construed or interpreted. We have the issue of undue influence, and that's becoming an increasing focus of litigation. In many states, because of the concern about elder abuse, there are now some statutory presumptions about what is presumed to have been a product of undue influence. Or the other issue is lack of mental capacity. And there are issues about that. And when we have clients that come in and they've had a stroke or they've got some kind of dementia that is starting, there can be a concern, and we need to inform the client about the potential for having to deal with that. The lack of legal formalities. I wouldn't say that's a huge thing if it's an attorney drafted document. Once in a while we lack a witness or we lack something that should have been done correctly. And then of course there's the issue of how to interpret the documents. One of the big problems that we have is that we end up with ambiguous provisions. We end up with provisions that nobody really knows exactly what was intended, or it seems clear enough, but they're subject to different possible interpretations. Another area of potential dispute is in fiduciaries, and when you inherit, there's always a problem with, especially if you're naming family members and not a corporate fiduciary. You're going to have a problem with jealousies. You're going to have a problem with biases. You're going to have a problem with perhaps having some kind of felonious past. One of the things that comes up are the conflicts of interest. Now, a conflict of interest doesn't generally disqualify a fiduciary because the courts have consistently ruled that if the testator or the settlor picked this person, they knew that there'd be a conflict. But if you pick one child to be the trustee or the executor, and you've got other children, there's inherently a conflict of interest in the way it's the estate or trust is being managed. And then, of course, there's the question of where is the fiduciary going to carry out their duties? What's the location of the administration? Jonathan, let's move on to the next slide. I think you want to discuss the breaches of fiduciary duties.
Yeah, but let me mention one thing about the interpretation of the implementing document. One of the things that I did more and more when I was practicing was setting forth an expression of intent. When I knew there might be more than one way to construe something, and I think that's true for everything, I would put in basically the result I wanted. For example, if you were doing a special kind of charitable bequest or a marital bequest, I would put in that either I or the grantor directs that this provision shall be construed and the property relating to it carried out so that it will qualify for the marital deduction. You could similarly put in things about how you want to have something interpreted where it's not clear. The reason that that's important is that the courts have uniformly stated that the goal of any construction or interpretation of an instrument is to ascertain the testator's or grantor's intent. And once that intent is determined, you have to construe the instrument, even if you turn negatives into positives or have to add words or take out paragraphs to achieve that intent. That has saved my bacon many times in tax matters, and you can also use it for other things. And so that's very worthwhile putting in.
I couldn't agree more. I think that it's very important to state intent, and it's very important to give examples if you've got complex provisions.
Lane, I completely agree with you. I was scolded as a young lawyer when I wrote a will which was very complicated, and I put in an example, and the partner I worked for at a law firm said, you know, good lawyers just don't do that. They just use language so it's clear. By the way, the document which we were looking at, which he had drafted, wound up in a big construction proceeding. So there you go. A breach of fiduciary.
And the key to construction and with the judge is going to be the four corners of the document. The more we put in the document, the better it's going to be able to be construed.
That's true. And in some states, like New York, if you have a will, you can't even present any evidence to contradict the terms of the instrument. In order to bring in evidence in a will contest, the instrument basically has to be ambiguous on its face. And whether something is ambiguous or not is all in the eyes of the person reading it. There are also disputes with respect to fiduciary duties, including the duty to account. For example, in most states, you have a duty to keep the beneficiaries reasonably informed. Some states permit you to, at least for a time, waive the duty to even let the beneficiaries know about it. Another thing that can be done is you can have someone else sign off on actions taken by the fiduciaries. Florida and Alaska, Elaine, I don't know whether you have something like this in Nevada, has a provision that if you send a financial statement to the beneficiaries, anything disclosed in that financial statement, plus anything reasonably to be inferred from that, the beneficiaries have only 6 months to object. Otherwise, it's waived. So it's like doing an accounting every 6 months. Then even if your state doesn't have that, I think it is worthwhile putting that into your documents. You can take a look at the Alaska or the Florida law and see what's in there. And number one, maybe you want to try to use that state law, and we'll get more into whether or not you can control the governing law for an instrument, including a will, or whether you just want to put in language to that effect. And in most states, I think that that would be enforceable. Another one is that the fiduciary has to act in good faith with respect to the trust and applicable law, and that's a duty that I do not think can be waived. In fact, one of the fears I've had is that if the fiduciary does not have to act in good faith, you may not have a fiduciary relationship at all. If it's in a trust, you may not have a trust. So I would be cautious in waiving the duty of good faith, but you can certainly put it in. Next, you want to make sure that the fiduciary is loyal and avoids self-dealing. One of the surprising things I learned as a young lawyer is that self-dealing, having the fiduciary buy or sell or have dealings with the trust of the estate, it even applies to two different trusts. So if I'm trustee for the Erdman family and I'm also trustee for the Rushforth family, I can't buy and sell between those two trusts, even though I have no personal interest, unless the instruments permit it or I go to court and I ask for it. And keep in mind that that's very important, because if you commit an act of self-dealing, the transaction may be void or voidable. And that's especially important when it comes to tax matters, when the IRS comes in and you think you've accomplished some great tax effect and the IRS comes in and says, hey, guess what? It was void or voidable, so we're not going to pay attention to it. The fiduciary has to be, as a general rule, impartial to all beneficiaries, but you're allowed to relax that to some degree in the instrument. For example, if you have a trust for the surviving spouse and the descendants, you can put in that it's okay for the fiduciary to prefer the spouse over the beneficiaries, or if you have a trust, say, for a child and the child's descendants, you can put in, and I almost always do in my instruments, that it is the intention of the testator or grantor to prefer the child over the other descendants. So you're not limited in what you can do. Obviously, you have to make prudent investments. That's a requirement. And a prudent investment is one that a man would make in a prudent manner where he's trying to get, or it's trying to get, a reasonable return with preservation of capital. But again, you can, as a general rule, relax that. Also keep in mind that in many, many states, New York has a very strict rule about diversification. So if you want something different, if you don't want them to have to act in the typical prudent person manner, you really put in language to that effect. And in fact, as Lane was suggesting, perhaps put in some examples like it's okay to have 100% equities. Or maybe it's even okay to have 100% fixed income, although I think we'd all agree today that if you had that in your instrument, you probably wouldn't want to do it. But at least have an authorization, if not a direction, to basically relax the strict prudent person rule of making investments. Lane, what's next on our types of disputes?
Well, before we move to the next one, I just wanted to comment. In Nevada, we do have a period during which people have to object to an account. But in most states, all of these duties can be softened or waived to a large degree, either in the terms of the trust or by consent of the beneficiary. So some of these are not hard and fast, but I agree with Jonathan that the duty to comply in good faith with the trust and applicable law is not waivable. It's not something that can be done away with. And I agree with Jonathan. I agree with you, Jonathan, that that should not be part of any trust instrument. The next type of disputes that I see are, typically postmortem disputes that deal with the distributions and the beneficiary complaining that they're not getting everything that they're supposed to. Part of that is debating of what's principal and what's income. If you have a trust and it says that a certain beneficiary, whether it's the surviving spouse or a child, gets income only and the principal's to be preserved, then we get into battles of the Principal and Income Act. And again, this is where we really want to be. I think this is where examples are appropriate, but we get people who have, for example, just something as simple as a trust deed and a note, and the husband and wife have been living off this payment. Well, part of it's income and part of it's principal. Clearly, that's not a dispute, but maybe the intent was that they get to spend, the survivor gets to spend that, including the principal. Well, we need to make sure the client understands when you say income only, what that means, and do we define income to include capital gain, at least realized capital gain. And then there's a dispute over who gets charged with what expenses, and ideally that's handled in the trust as opposed to just the default Principal and Income Act. Then there's arguments about asset ownership. One of the big problems that we have in particularly with trusts is asset ownership. If the trust isn't funded, then you can get an argument. And there are all kinds of asset ownership problems, including community property for those of us who live in community property states. For transfers to irrevocable trusts, you've got the issue of either fraudulent or avoidable transfers. And what can be done? Was it done with the intent to hinder, defraud, or delay creditors? And of course, we all create trust that after the settlors die, that the trust is a spendthrift trust. And then in some jurisdictions, including Alaska and Delaware and Nevada, we have a self-settled spendthrift trust. And those provisions are coming increasingly under attack. And that leads us to the final point on this slide, and that is jurisdiction. Where is the trust being administered, the legal situs of the trust, what laws govern, and what choice of law applies? And some people say, well, if you've got a declaration that the governing law applies, isn't that the end all and be all? And as you can see from court rulings, that isn't the end all and be all, because some courts will decide that there are public policies that need to be preserved, and that some of the choice of laws relate to procedure as opposed to substance. But if there is a key public policy that the governing law violates under the enforcing law's jurisdiction, there can be all kinds of battles. I'm sure you've seen some of this, Jonathan.
Absolutely have. Absolutely have. And Lane, why don't you take us to the next slide, if you would, and if you would at least begin handling that.
Okay. Well, here's the things that really get us to the meat of what we're talking about. We've up to this point talked about the problems, and then the first thing that we need to do in curtailing litigation is to see that the documents are well drafted. They need to be proofread. They need to be explained to the client. We make sure that the intent of the client is within the four corners of the document. The declaration of intent, as Jonathan suggested, is paramount. I think it's absolutely critical that there be a declaration of intent, and that as much as we can. Now, I don't think there's a perfect will or a perfect trust, but we need to do the best that we can. Another thing that is helpful is to involve the inheritors. Sometimes you can nip problems in the bud if you involve those that are going to be the beneficiaries of the trust or the beneficiaries of the will in the preparation of the document, so they aren't blindsided by something that is that they consider is last minute or aberrational in any way, shape, or form. I find that it's less problematic to use trusts instead of wills. You can accomplish a little more in control instead of using a will. It's just, the administration of trusts is a little simpler. In Nevada, we have a statute that says the court must enforce no contest clause. A similar type of clause is a conditional bequest, and that can even be used in states where no contest clause are prohibited in some cases. Some states aren't really in favor of no contest clause, but if you say, if the beneficiary does A, B, and C, then they get this, you can put in things like if you fail a drug test, or if you go to college, or if you can put some things, either things that give an incentive to do something or a disincentive not to do something. And then one of the tools that's growing in a big thing in today's around the country is that we're now having the opportunity to seek some pre-mortem court order to confirm the mental capacity of the testator or settlor, to confirm that there's no fraud, coercion, or undue influence, and to construe the documents with as to their intent and purpose, and to get a court seal of approval pre-mortem while the testator and settlor are still around to testify, and have a judicial determination in advance. Jonathan, what do you have to add to this?
Well, I mean, that to me is critical. As Lane was saying, the most important witness of all, which is the person who wrote the trust or the testator or testatrix of the will, isn't there. I mean, 5 states, we're going to get into this, permit pre-death admission of wills to probate, and more permit the pre-death determination of the validity of a revocable trust, which is often used as a will substitute. And where that happens, I mean, if the testator or testatrix comes into court, they're sworn in, they're asked questions, the court can, I think, readily determine in virtually all states whether or not they have the capacity to make a will, and they understand, you know, who the natural objects of their bounty are, the extent of their property, and so on and so forth, that it's not a product of fraud, it's not a product of coercion or undue influence. It's just a fantastic way to go. Now, there's an article written about 1.5 years ago by a lawyer who said, oh, this is wrong. Premortem probate is a bane on everybody's existence because people should be able to contest it after death. That's the best time to do it. Well, I didn't check, but my guess is that lawyers' practice might turn a little bit on will contests. And any lawyer who's involved in that will tell you that is a very, very lucrative area of practice. My view, and I admit I'm not in practice anymore, so you can say that's why he's saying it, but I tried desperately in my career to stop will contests and similar contests before they started rather than forcing it. But I really, really think that the best thing to do is to prevent those contests from happening. One of the reasons is if you wind up in a will contest, it's not just that tremendous amounts of money are going to be spent on the lawyers rather than going to the family or other beneficiaries, but you are also going to permanently destroy relationship among the participants, among the contestants. And that will not just be at the level like one brother suing another or a sister suing another. It's also going to affect the next generation. So cousins no longer talk to each other. It's a real shame. Remember the expression, you'll never know another person until you share an inheritance with them. And that is true. I've observed it and I have personally experienced it, and it's something that you do not want to happen because, again, it'll cause a real fight. I mean, money, is often said to be the root of all evil. And these contests, which are typically, not always, as Lane was indicating, are about money, you just don't want to go there. And using a premortem proceeding to prove the will, to prove the bequest, to approve the disposition of the property that's planned, I think is a great way to go. It gives you, by the way, work to do with your client right now. So if you anticipate it happening, please discuss it with your client.
I couldn't agree more.
Let's go to our next slide and talk about involving inheritors. Lane mentioned this, and I think that if you are going to have a disposition, which anybody might object to, from everything about, that the younger son is getting more than the older sister, or somebody is getting, the grandfather clock and someone else is getting the baby Thunderbird, which sometimes happens with respect to tangibles. And by the way, I was involved in a very, very big dispute long after the woman's death because of a fight over the piano. This was a multi-million-dollar estate, but the three daughters all claimed they were entitled to their mother's piano, which might have been worth on the outside $25,000 in a multi-million-dollar estate. But that was the genesis of millions of dollars in legal fees being incurred. And in fact, the reason I got involved is that one of the lawyers, a very fine lawyer, a member of ACTEC with a fine firm in California, knew that she was going to be sued by one of the daughters, the one that she represented, and I took over the representation. And by the way, when I did this, I had all sorts of agreements with that person about if she wanted to sue me for anything, she had to follow a certain route and so on and so forth. But getting the inheritors involved in the plan means the following. My mother leaves more to my brother Doug and less to me. Well, if my mother has told me about that ahead of time, I can't very well, after she dies, saying it was my brother who forced her to do it. She's spoken to me. I have an opportunity for the rest of my lifetime to argue with her or try to get her to change her mind, but I can't then blame my brother in all circumstances. At least you have the matter there, again, while the parent is alive. Critically important. Also, you can have inheritors in different roles within the plan. For example, it may be that you want the middle child to be the executor or the trustee rather than the older or younger one. Maybe you want all three. But I can tell you, if you have only children, even though they seem to get along great, I would recommend a third-party tiebreaker. So when the younger child says we're going to the left, and the older child says we're going to the right, maybe that's a tax matter, maybe it's a settlement with a creditor, no matter what it happens to be, you have a tiebreaker who can go in and make the decision. The other thing you can do is to have the inheritors sign a binding agreement before death that they will accept the terms of the instrument. And in fact, as we'll get into, you can even condition them getting it that they have signed or will sign some sort of agreement reducing the risk of expensive litigation after death. Again, I want to emphasize, I've never had a client, and no one on the phone has ever had a client saying, I want my wealth to be used to create disputes after I die so that family relationships will end and a lot of my money goes to the deserving lawyers. Lane, I don't think you've had that happen either.
Absolutely not. And we did have a case where we had a family where there was an operating business, and the son and not his three sisters ended up with that operating business, and that was a sore spot with the sisters. And so the decedent's three daughters, well, before she was deceased, the settlor's three daughters, she knew that they were going to fight. And so she had them sign a binding agreement saying that it was a non-interference agreement, that they were going to accept what they were being provided. It included actually a ratification of the entire estate plan, which included irrevocable trusts and the revocable trust and a business succession plan. And it was all proposed in writing, and they signed it, and it became something that we could use when they inevitably filed a lawsuit after she died, because the court didn't buy their argument. They tried to say mom pressured us into doing that. One of the things we did in that particular case is that mom actually paid them consideration. So instead of just being in an unsupported contract, they had been paid each several $100,000 to agree to that. And we were talking about a very large estate, so it was all worth it. And but you get into a complex estate plan where there are a lot of moving pieces. The informing the inheritors and getting them to buy off on it can help.
Absolutely correct. One little footnote I want to drop here is if you're leaving, say, the business to one child and other assets of equal worth to the other children, you have to be very careful about your tax apportionment clause. For example, you make a pre-residuary bequest or disposition under a revocable trust to the business to child A and the balance to children B, C, and D. And then you have a tax direction clause which says pay all taxes on property passing under this instrument out of the residuary estate. Well, that means that the kids B, C, and D who are getting the balance of the estate and not the business are going to wind up paying estate tax on the value of the business. You've got to really think about that and actually obviously run some numbers or perhaps put limitations on inheritances of the business to one particular child. I mean, that's something that needs to be carefully considered, and that in turn obviously will cause you to think about some other pre-mortem estate planning, which obviously is good for the client, good for the inheritance, and also good for you. Lane, let's go, if we could, to our next slide, which is planning with respect to trusts. Now, one of the things I think you want to consider if you are at all concerned about some sort of will contest is a revocable trust. And Norman Dacey, who was not a lawyer, wrote a book many decades ago called How to Avoid Probate. And that had been something that was developed by James Kasner, a very famous professor of estate and tax planning at Harvard, who wrote an article in the 1961 Columbia Law Review about how you could avoid probate using a revocable trust. This was unheard of. Everybody now knows about that, but when he did it, it was extraordinary that he did it. Well, Dacey picked up on that, wrote a book, which was really a lawyer bashing and a judge bashing article. He sold 11 million copies of the book and became obviously a very wealthy man. By the way, there were a lot of problems, especially on the tax side, when he said put everything into a revocable trust. In fact, he said put your cat in one trust and your dog in another and one house in this and your furniture. You'd have about 50 trusts. It was unnecessary, but people began to pick up on it in any event. There are, however, today very few adverse tax effects of using a revocable trust as opposed to a will, and there are a couple of cases where maybe you will be better in using a will and taxes, but it's relatively rare. And especially because you can now make that election under Section 645 of the Internal Revenue Code, where your former revocable trust is treated as part of the decedent's estate. So, for example, some of the benefits of making distributions of gross income to charity can be more favorable if made from an estate as opposed to a former revocable trust. But again, by making that election under Section 645, the revocable trust will be treated for a long period of time, generally, as part of the probate estate for income tax purposes, and you can get virtually all the benefits. A big advantage, not just avoiding tax problems or generating tax problems using a revocable trust, is a revocable trust is generally more private than a will. You have a will, it's admitted to probate. When we handled Jackie Onassis' estate, I got dozens, if not hundreds, of requests from my colleagues. We want a copy of Jackie's will. Well, the children told us not to do it, so I would have to send people to the probate court, but they got a copy from the probate court. If we had had a revocable trust, it wouldn't have been before court unless some action with respect to it occurred, and it would have kept things much more private. Also, unlike probate, it doesn't automatically trigger a court proceeding. In New York, for example, when you offer a will to probate, you are actually suing those who would have taken in intestacy or under another will that's on file. And people get a legal notice. Now, generally in New York, we go to the beneficiaries who are inheriting. They're the same people who would take if there were no will and ask them to consent to this instrument being admitted as the last will and testament of the property owner. That's not true in all cases, but in all cases, the will is going to be the subject of a lawsuit. In New York, it's much more formal. That's called solemn probate. In other states, such as Florida, you can use, common probate, and you don't have to really have a formal contest. But with a a formal court proceeding, but with a revocable trust, you needn't have any before. An irrevocable trust is very, very difficult to challenge, especially if the person who created the trust, the grantor, has taken actions with respect to it. It's irrevocable, and it may be subject to some change, but it's there. Now, suppose you say, yeah, but aren't I going to make a gift if I put everything in an irrevocable trust? The answer is no. If you retain virtually any power to change the beneficial enjoyment of the assets in the irrevocable trust, transfers to it are going to be incomplete for gift tax purposes. So you can do that in some cases, especially if you are anticipating some sort of contest based upon a variety of factors. So you can put in a lot of techniques to prevent some sort of challenge to that irrevocable trust there. But if you're anticipating some sort of challenge, a revocable trust probably is better, with one exception. And that's with respect to capacity. In order to have a revocable or irrevocable trust, the person has to have the capacity to enter a contest. At least in New York, there is a lower threshold of competency to do a will. So if you have someone who doesn't have the instrument or it's not right, and you know there's going to be a challenge, you may be better off, if that challenge is going to be on capacity, to use go ahead and use a will rather than a trust, because the trust may have a higher level of capacity requirement than does a will. I've never actually seen that in my life, but it's at least a possibility where you'd want to consider it. Let's go, Lane, to the use of no contest clause, and please tell us about that.
Just one comment about the contractual capacity versus testamentary capacity. In Nevada, there's no clear-cut rule. I've researched around the country, and it's really hard to distinguish. But I do agree with you that we need to, when you get into the more complex planning, the idea that a testator or settlor has to understand the complexity probably requires a higher level of capacity. On no contest clause, the whole idea, and this goes back to Jonathan's point earlier, is that no settlor, no testator really wants litigation to pursue. And so it's very common to put in, except in the states that prohibit it, it's very common to put in that anyone who contests this will or trust is going to get zero or going to have their share reduced in some way. nice thing about this is that it's kind of a discouragement factor, even when it may not even be well written. But in addition to a contest, you can add other triggering events that might trigger a forfeiture of a beneficiary share, such as suing the fiduciary without in bad faith or without good cause, and actions against one beneficiary against another. And so you can define triggering events. And of course, the effect can be divestiture, reduction. One thing that happens sometimes is people say, well, I don't want to take away their share, but I want to turn their outright distribution provisions into a discretionary trust, that kind of thing. The no contest clause in most states is going to be strictly construed. So if you're not clear about what's going to trigger it, it's going to be very narrowly interpreted. And so this is a place where there needs to be some declaration of intent here. And one issue that's come up in a number of courts is this just boilerplate that's tagged on at the end, or do they really mean it as a material part of the trust or will? In my trust, under the section that declares the intent, I specifically reference the no contest clause to make it clear. I really want this. This is something I picked. Jonathan, what's your experience with no contest clause?
Well, I've had quite a bit of experience with them, and they are enforceable in New York, but as you say, they are narrowly construed. In Florida, they are not permitted, but what I've done with clients who are former clients of mine in New York who moved to Florida and wanted a no contest clause is to either, one, direct original probate of the will in New York, saying that New York law will control on everything, or two, even better, have them do a New York revocable trust with a New York trustee, and then I think it's going to be supported. In addition, Alaska has an exceptionally strong inter rorum provision for trusts, and I have used that very, very well. I won't go into the detail, but I was able to stop a huge potential lawsuit that one sister threatened to bring 2 days after the father died. I had that sister's lawyer read it, and it basically said, if you challenge this or any other instrument I've done, if you sue any member of the family, and you don't win on clear and convincing evidence that it was, a very bad thing, you are going to be treated as though you predeceased. And the lawyer called me back and he said, oh, that letter that my client sent to yours about suing her and hiring the most vicious litigators in the world, that was a joke. It was a bad joke, but it was a joke. And it so frightened the other side that every time they'd call me in the future, they'd say, now, we're not threatening anything. We just want to ask a few questions. It really, really worked in that family to, prevent some sort of horrible litigation, which would have ruined relationships between the two sides of the family. So I think they're really great. But again, if you're in a state where it may not be enforceable, consider using a revocable trust, which clearly permits it. Is it okay in Nevada, Lane?
Absolutely. And like I said, we have a statute that specifically directs the court to enforce them. Because our time is kind of running on, I'm going to jump to the next slide. Just quickly, there are a number of things in drafting the documents that can help reduce disputes. One of the problems I mentioned earlier was the idea of what's income and what's principal, and one of the techniques that really dissipates that and is to provide for, instead of an income-only distribution, provide for a unitrust provision. And that way they get it really makes it for better investments, and they get a set percentage amount instead of having to argue about what's income and principal. In most states, a lot of discretionary beneficiaries have limited ability to contest and dispute what fiduciaries do. And so discretionary distributions can discourage disputes. Now, sometimes you don't want it all to be discretionary, and you want some distributions to be made, and some abusive trustees can use discretionary distributions as a weapon. So you have to be careful. The key to there is picking the right trustee, because you really don't want somebody who's got a conflict of interest exercising the discretion inappropriately. Having multiple beneficiary shares, again, a discretionary trust that allows sprinkling among a pot of beneficiaries is a good thing. Beneficiaries are less likely to contest and create problems if they know they can be removed under a power of appointment. You've heard the phrase, power of appointment can also be a power of disappointment. And so that's something that can discourage beneficiaries and help them kind of toe the mark and do things. And then somebody like a fiduciary or a trust protector could have the power to grant or cancel a beneficiary's power of appointment. Those can be techniques that can help a beneficiary or help discourage a beneficiary from contesting anything. Any comments, Jonathan?
Well, all of those, we could spend a tremendous amount of time on this. I personally like discretionary distributions for trust with some suggestive language. And in fact, I typically tell very wealthy people like Lane's family, we don't have to provide Lane with money for vacations and, for meals and stuff. The big expenditures which you're going to have, which is buying homes or recreation property like a ranch or a ski lodge or something like that, or works of art, we can buy it for the beneficiary. In fact, I'm trustee of some very large trusts, and I own well over $150 million in homes and works of art. And what I do is I buy it, I pay for it, I pay for the insurance on it, but I allow the beneficiary to use it for free. And the friends and neighbors think she owns the house, and they think she owns the Chagall or the Kooning or whatever the work of art may be. And there are some very good effects of that. Number one, we no longer have the beneficiary own it. If I gave money to the beneficiary and she bought it, well, she might be sued by a creditor who tried to get it, or her husband in a divorce or something like that. Here she doesn't own it. No creditor and no spouse can try to take it away from her. Number two, unlike making distributions to the beneficiary, the rent-free use of property owned by the trust by the beneficiary does not result in imputed income to either the trust or the beneficiary. You might want to write this down. There are two key cases on that. One is called Plant, P-L-A-N-T, and the other one is called DuPont. You will find those, if you don't have a citation, in the book I do on the income taxation of estates and trusts with South Carolina Professor Ladd Boyle. But all these things are very, very important. One of the things that I also eventually wind up urging my clients is, yes, give your children powers of appointment, but make sure it can only be exercised with the consent of some independent third party, so that the child is not pressured by her older child, by her husband, or by his wife to exercise it in a certain way, or even charity. So again, I became more conservative in powers of appointment. I love them. I think they're one of the greatest things of all. In fact, I probably use decanting more to grant powers of appointment than for any other reason to decant. But consider putting in some sort of limitation in what the beneficiary can do.
Great.
All right, next we're going to turn to mediation and arbitration. Florida has passed a law which allows arbitration provisions to be enforceable, but of course if you have it in the will and the will has not yet been admitted to probate, you can't get it. And I don't know of any state that has a mediation provision. So what I've done is I put in making the bequest to the children conditional on their agreeing to mediation and arbitration. So I say, if but only if my nephew Matthew D. Blotmacher signs a document which, before notary public and with the advice of counsel, and I put in the counsel has to sign that Matthew's been advised, that he will agree to mediation for a period of 6 months in good faith, and if he fails to exercise it in good faith, and he also has to agree to arbitration before, the American Arbitration Association or whatever you want. If he does that, but only if he does that, then I leave my Cessna 185 float plane to Matthew, which he really, really wants. And he's nice to me because he's hoping that I will bequeath that to him. And Matthew, I probably will. But I'm going to condition it. I'm going to say, if but only if Matthew agrees to this stuff, then I make the bequest. I'm not saying I make the bequest, but if he does something bad, I take it away. And that kind of additional bequest, I think, is much more likely to be upheld, even in states where inter rorem provisions are not. I've had some Florida lawyers who say, no, we'd find that. Well, again, have the will admitted to probate in another state, or have the revocable trust controlled by a state like Nevada or Alaska, which will enforce these things. So that's a very clever thing you can do, but that way you can get mediation and arbitration if there's a serious dispute, and avoid the terrible expense and the trauma of having very, very serious, post-mortem fights. And in fact, you can even do it with respect to fiduciary action, that they've got to agree to mediation, and if mediation won't resolve it, arbitration in order to get the bequest. And I've never had a beneficiary turned down. The one thing, in my experience, Lane, you can count on people's greed. And, if you're talking about a significant inheritance, and, my claim for Matthew, which is probably worth about $100,000, is a huge part of my wealth. Matthew knows that. I don't think Matthew's going to take the chance of saying, forget it, I'm not going to agree to the arbitration and mediation. I'd sooner forfeit it. He's not going to do that. He's going to say, yes, I will agree to mediation and I will agree to arbitration so I can get this bequest of the plane.
Agreed. And in Nevada, by the way, mediation and arbitration clauses are specifically enforceable. We're going to jump into premortal legal action. I don't think we don't have much time left, but I'll just quickly go through this. The key thing is that while the testator or settlor is still around as a witness, and while the evidence is fresh, and while the beneficiaries are less likely to challenge, that's the time to jump on the action and do things. The advantage is that the testator or settlor chooses the forum. The court can be requested to declare and construe specific provisions. And asset ownership disputes can be part of a declaratory relief action. So a lot of this can be done, and one of the course challenges is convincing the clients that they want to pay for this kind of thing. But in the appropriate family dynamic, if you know disputes are going to happen, whether it's a problem with undue influence, or whether it's a problem with a child getting a business when the siblings want it, those things can all be addressed in a premortal legal action. Arkansas, Ohio, North Dakota, and Alaska and Nevada are the jurisdictions that I know of that permit premortem actions. But I also know, as a member of the State Laws Committee of ACTEC, is that there are a lot of states that are working on this, and maybe even some that have adopted it this year that I'm not aware of, but that's very active. So because our time's limited, I'll turn the rest of it over to you, Jonathan. I'm not hearing.
Oh, it looks like maybe we lost you, Jonathan. Are you still there?
Yeah, I'm here. Sorry.
Yep.
One of the things that Alaska permits premortem probate, and it's one of the very few states that expressly provides by its statutes that a non-resident can direct for her will to be admitted to original probate in that state. Two of the biggest will contests in modern time was the estate of Seward Johnson, and the other one was the estate of Doris Duke. Fabulously wealthy people who, although they did not live in New York, directed original probate in New York, because New York has had a statute for over 100 years trying to encourage business for New York lawyers to have their wills admitted to probate in New York. So that's common. Alaska permits it, and also permits premortem probate, and a number of our colleagues who, for non-Alaskans, have had their wills admitted to original probate there. So that's something to consider. Now, you'll get some resistance from clients about the expense, but again, as Lane was saying at the beginning, and as I kind of rounded out, it's good to talk to the inheritors ahead of time. And you can go ahead and talk to the client and say, look, this will reduce the probability of post-deaths disputes, the cost, and the ruination. Now, there are some things that you need to consider. If you do something with respect to your instruments and you change domicile, is it going to change? You have questions about if you want to have an amendment to a trust or a codicil to a will, the acquisition of additional assets in a revocable trust. But again, if it's merely by some sort of purchase and sale, it shouldn't be a problem. Validity in non-domicile estates. Well, again, Seward Johnson and Doris Duke, non-New Yorkers, had their wills admitted to probate in New York. Nobody disputed that. It appears as though that is permitted and it should be respected. So that's something that you really can do. And I think that, it will be respected. I think that if you want to really go the maximum, you do a revocable trust with a trustee in that state. You want to use Nevada law, which Nevada has some great laws. You better choose a Nevada trustee or co-trustee, have some assets actually in that state, whether it's bank accounts or brokerage account or whatever. You can still have assets in the other state. But if you have, say, land in Montana, Texas, New York, Florida, and you're worried about, well, you really can't control that with a Nevada directed will, what you do is you convert that into an intangible, like a limited liability company, maybe one that's disregarded for tax purposes. That way, it's all going to be intangible, and it should be able to be controlled by either the revocable trust to which the LLC has been transferred, or by the will, which will control its disposition. So those are some of the things you can think of. I urge you as strongly as I can to consider discussing these matters with your clients, and let's get, constitutional procedural challenges. You may make it, but again, if you put in some sort of provision that if you contest this, you're not going to get your inheritance, you're making the inheritance conditioned upon agreeing to it ahead of time. Unless my nephew Matthew agrees that the provisions of this instrument shall be controlled and shall be construed under Alaska law, then he doesn't get the inheritance. Again, he's going to have to be absolutely positive he's going to win, that that's not enforceable before he's going to go on it. Who's bound or not bound by the order? Very important case called Mullane by the Supreme Court a number of years ago, in which they held that you could actually make people bound by an accounting proceeding with respect to a trust in New York merely by first-class mail, even if they were not New Yorkers, because some of the contestants said, oh, yeah, we got notice, but we didn't get personal notice, and we weren't in New York, so how can we be bound? The Supreme Court in Mullane said they are. That's a very old and important case, and it would appear to apply to virtually everything with respect to probate-related matters. Remember, even when you have, a jurisdiction, those special rules for federal purposes don't apply to probate matters. That's really something that the decedent and his or her lawyers can basically control. So anyway, I hope we've given you some food for thought. Before I ask Lane for his final remarks, Deb, do we have any questions?
Yes, we do. And thank you, everybody, for joining us today. We do have several questions, Jonathan. We are out of time, but if anybody wants to stay on, I think we're going to try to hit a few of those questions before we let go. Before that, I'll turn it over to you, Lane, for any final comments.
Why don't you go ahead and let's do the questions first.
All right. So the first question that we have is from, sorry about that, folks, is Juliana Velasquez. In regards to pre-mortem probate, what happens to any child born after the decedent's death or if the decedent remarries?
Well, under Nevada law, our pre-mortem says that if you do the pre-mortem probate, the will is valid. But under Nevada law, we also have a pretermitted heir statute. So if a child is subsequently born, they are going to be entitled to their intestate share unless the will is subsequently redone. As to a spouse, we have the similar issues. If there's a remarriage after the will, under current law, the new spouse would be entitled to his or her intestate share. So the will, as admitted in the premortem probate, is going to be valid, but the in terms of the subsequent changes, you have to keep it current, and so you can't just let it sit. But as to the people who are in charge, I mean, the people who are vested, they get that. The will is considered valid.
Okay. Thank you, Lane. Appreciate that. Next question from Robert Burney. Can the life insurance agent be the trustee for an ILET to which he sells the second to die policy, and does this violate the self-dealing rule?
The answer should be no. However, I know that most insurance agents do not like to be trustee of the trust, but I don't know of any reason merely because he has sold the policy to do it. But what you do is you expressly put in the irrevocable life insurance trust that it is a valid purchase by the trust, even if the agent and acknowledging that she will get a commission is selling it to the trust. So again, careful drafting, I think, leads you in a good place. Let me mention one thing about arbitration. People sometimes say, well, I don't like arbitration because the arbitrator can be arbitrary, and that's certainly true. But what you can do in your arbitration provision is to allow the person who lost the arbitration or who doesn't like it to go to court, and if that person can prove, and maybe you want just to by a preponderance of evidence or by a higher standard, such as clear and convincing evidence, that the decision of the arbitrator was clearly contrary to the law or was arbitrary, that it's going to be, can be ignored. One of my former partners at Milbank brought a suit against Milbank. Milbank's partnership agreement provides that all of our disputes have to be before an arbitrator, and my partner lost. And he went to the New York Supreme Court, which is the highest court of general jurisdiction, and they said the arbitrator was completely wrong, and they struck down the arbitration. It was appealed to the intermediate court, the appellate division in New York. They too said this is completely wrong. He applied the long law, completely wrong, so we're overturning the arbitration. But it went up to the New York Court of Appeals and our highest court, and they said it's wrong, it's ridiculous. He applied the long law, but we are going to enforce the arbitration provisions. That's the thing you have to worry about. But again, when you put in the arbitration rules, you can put in that if you can establish that it was wrong as a matter of law, or it was completely arbitrary, or it's not a sound judgment, whatever you want to put in, then you can go to court and make sure that you haven't been, haven't been screwed by the arbitration. So the arbitration you can generally prevent from being arbitrary. Deb, any more questions?
Yes, we do, Jonathan. The next one comes from Darren Richardson, and it's a two-part question. First part is, some clients want the drafting attorney or the firm to be the trustee of their trust. First, is this ever a good idea? And second, what are some basic things the attorney or law firm can do from the onset to prevent litigation?
Well, that's great questions. Some firms prohibit it. I would guess most of the big accounting firms now say you can never be a fiduciary for a client. My law firm for many, many years discouraged it. I think in part because it was perceived that the Chase Bank, which was our major client for decades, would think that we were competing against them. Firms in Boston very regularly serve and in fact encourage clients to use them as the executor and as the trustee. There's nothing inherently wrong about it, but the ethical rules say you may not suggest that you become the fiduciary. In addition, in New York, unless there's a specific provision to the contrary, you lose part of your commissions if you were the drafting attorney. So that's something to watch out for. And in fact, in some cases, it might be worthwhile to say to your client, okay, we will act, or one of the partners will act. Remember, a firm alone can't act as a fiduciary, but the partner will act as a fiduciary, but you have to go to another law firm to be counseled about that. That, I think, is the best thing you can do. And if you've gone there, then if you want to put in all sorts of things about the trustee or the executor will only be liable if he or she was arbitrary and capricious, if they acted recklessly, they had to at least guilty of gross misconduct of some kind. If you've had the client go to another lawyer, and if they really want you, you tell them that. That way you can really go much, much further to protect themselves. Lane, how do you feel about that?
Well, number one, I agree with you that there's nothing that prohibits it. The first thing I would say is that I would recommend against any firm doing that unless they have the personnel and the experience to act as trustee for the particular client. I've seen attorneys who automatically make themselves the fiduciary in a lot of wills and trusts, and they don't have the people that could handle a complex estate, and they don't really have the intellectual capacity to deal with what needs to go on, and they end up either not doing it correctly, or they end up having to farm it out and actually be a co-fiduciary with a corporate trust company. And our firm is a small firm. We do not do it, but I think if you have the resources to properly handle the administration, and clearly, if you're going to have a partner be the fiduciary, and your firm is going to represent them as fiduciary, you've got to have some very careful documentation where the client is understanding that there's an inherent conflict of interest and that they are okay with that.
Two more points on that. Number one, you better make sure that your malpractice insurance covers actions as a fiduciary. And number two, one of the things I've done for about 40 years now is to have different people fulfill different fiduciary roles. So, for example, I would very readily accept, unless it was a crazy family, to be the distribution trustee. So I would make decisions on distributions. But I don't have the time to make investment decisions. And the most I've ever accepted is the authority to choose someone like a Morgan Stanley or a Goldman Sachs or a UBS or a Peak Trust to make the investment decisions, because I just don't have the time to watch the stock market every day. But using different categories of fiduciary positions, I think, can make it easier for the firm to do that. But Deb, that was only part one of his question.
Well, I think you got through both sides, Jonathan, of his question. Right. And I'm going to take one more, if that's okay.
Yeah.
Okay. Next question comes from Patricia McMillan. If a beneficiary requests a trust accounting and receives only a 1041 for the trust, does that mean the duty to account and start the time limit to object to it?
Let me answer that from the Nevada law. The first thing that the trustee has to do is look what's required in the trust instrument itself. If the trust instrument is silent, there are, in most states' laws, and specifically Nevada, a certain amount of information that must be provided. It can be provided electronically, but a 1041 is not sufficient unless the trust itself says that it's sufficient. So they are entitled to more under the default provisions of Nevada law, and I suspect under the default provisions of most states' law.
Yeah, I don't think even in Alaska or Florida that just sending a 1041 is sufficient. I think you need more of a thing that would show, the timing of investments, the prices paid, because on your 1041, it's certainly not going to show assets that have been held and not sold, and it may not show new assets that have been purchased. So having at least kind of a QuickBooks accounting readily available and sent to the beneficiaries makes sense. In addition, if you've got, a trust company or you've hired a professional investment firm like a Morgan Stanley, they can provide financial statements which can be sent. If there's anything different that's been done, for example, showing the rent-free use of property to beneficiaries, which is one of the things that I mentioned I often do, I actually show that on the account so that the beneficiaries all know that I have purchased a home and allowed the older beneficiary to live there. Keeping people informed. I want to emphasize this. Keeping people informed is your best protection against being sued. And that's for fiduciaries, and that's also true for lawyers.
And I couldn't agree with that more. It's really important to keep everybody informed, and clearly they're entitled to know what receipts came in, what disbursements were made, how expenses were paid, where it got paid from. All that is appropriate for a trustee's account.
Now, I said that was the last one, but would you gentlemen be okay to one more?
Of course.
All right. One more question from David Sterling. How about power of attorney limitations over specific trust assets? For example, annuities which carry a pretty hefty tax and possible penalty consequences if subject to POA.
Deb, would you read that again? I'm not sure I got it.
Well, actually, I take that back. David Sterling has a kind of a series of questions. My apologies. So I'm going to skip that one, and I'll let you handle that offline to Mr.
Okay,
Sterling.
send it to us, please.
I will. All right. So with that said, we are going to wrap it up, everyone, and we do appreciate your time, and thank you very much to Lane and to Jonathan for spending the hour with us this morning. I hope everybody that was in attendance enjoyed it. And please remember, we have recorded this, and we will send you a copy of that recording. And if you have any other questions, please feel free to send us a quick email. So thank you, everybody, and have a wonderful day.